Good afternoon. Thanks so much for being with us today. My name is Janice Kaminer-Resnick, and I welcome you on behalf of the members of our leadership team, which includes myself, former Congressman Mel Levine, and former Los Angeles County Supervisor Xavier Oslovsky. Thank you and welcome to our very special guest tonight, Linda Greenhouse, who we've listened to for years and read for years, and we're very excited to hear her tonight for the full hour in person, and to our wonderful moderator, Patt Morrison. We are so grateful to both of you for being with us and to gain your insight, and look forward to gaining your insights about the High Court. Reminder that this week we are hosting two programs, as we are almost every week between now and Election Day. In addition to tonight, on Wednesday, we welcome back former Secretary of Defense and so much more, Leon Panetta, who will discuss an expert's view on our world in chaos. He will also be in conversation with Patt Morrison. Next week after Labor Day, we have programs on both Wednesday and Thursday. Please note that, of course, Monday is Labor Day. September 4th, Max Boot will be discussing From Reagan's GOP to Trump's MAGA, Where Are the Republicans Headed? And on Thursday, we will host two Stanford scholars who just completed an epic report on anti-Semitism on college campuses. Larry Diamond and Jeffrey Kosoff will discuss the disturbing findings from their study and have recommendations about what should be done about anti-Semitism on college campuses. I'm sure you'll all want to come to hear that. Reminder, all of our programs are available via podcast and via our YouTube channel. Links to all those access points are in every email we send. And if you have problems finding them, send me an email, and I almost always respond. So we really want you to be able to access our programs, and we want to encourage you to send our links to friends, especially this year. It's so important that we have an informed electorate. Now, to introduce our moderator, who will introduce our speaker, please welcome Patt Morrison. Patt Morrison is a writer and columnist for the Los Angeles Times. She is very well known for her work hosting programs on public television and radio. She has received 6 Emmys, a dozen Golden Mikes, and parts of Pulitzers. I think that was with the LA Times. She is one of the most notable and beloved broadcast journalists in Southern California, and a brilliant and terrific person. We are very fortunate to have Patt moderating tonight's program. So now I'll hand the program over to Patt. Thank you, Patt.
Thank you, Janice, and thank you to everyone who's watching and supporting this program. And tonight we want to thank especially our special guest, Linda Greenhouse, who for more than 40 years was the New York Times Supreme Court correspondent. She won a Pulitzer Prize for her reporting on the court. And after she left the Times, she taught for 14 years at the Yale Law School. She is the author or co-author of 6 books about the court, including most recently an updated 3rd edition of The U.S. Supreme Court, a very short introduction published by Oxford University Press. Linda, I'm so glad you could join us tonight. Thank you.
I'm so glad you invited me.
When you started covering the court, it was the Burger Court. It was 4 or 5 years out of the Watergate decisions that, well, were very seminal in limiting presidential power. So here we're trying to sum up 40-some years briefly, but we see a very different court right now than what it was, the Burger Court post-Watergate, when you started covering the court.
Yeah, I've been thinking a lot about this, thinking about the new term that begins this coming first Monday in October. So back in the late 70s, when I first kind of got acquainted with the court, it wasn't that long after a very active Congress under Lyndon Johnson, under Richard Nixon, had passed some of the foundational statutes that kind of define modern America, all the environmental laws, the civil rights laws, the voting rights law, all that stuff. And what the court was doing at that time was kind of building out the meaning of those statutes. Many of his most important cases back then were cases of statutory interpretation. What does clean water mean? What does worker safety mean? That kind of thing. Now, looking at where we are today, we have a court that's dismantling that structure. The modern American statutory structure that Congress built 40, 50 years ago is being really ripped to shreds by a majority on this court that is at war with the so-called administrative state, and really is arrogating to itself a great deal of the power that by the civics textbooks and by our past experience really belong to Congress and to the president.
We've heard for years about that past court, the Berger court, even the Rehnquist court, that those were activist courts, that they were overstepping what it was they were supposed to be doing. Now we're hearing just the same about this court, which in some portions of this court looks at itself, as far as I can tell, as remedying what it thought of as overstepping by those earlier courts.
Well, yes, I mean, that's true. Somebody like Clarence Thomas or Sam Alito uh, believes in a very fundamental way that American law, American constitutional law, got off on the wrong track sometime after the New Deal, and that their mission is to bring it back to what they consider to be the original understanding. I mean, that's a whole other issue about how do you interpret the Constitution. And there's always been pushing and pulling and that kind of thing. But the kind of state of war that these justices are in against modern American law is something that's pretty striking.
That idea of originalist has been mocked because people will say, well, if you really want to be originalist, put on your stockings and your buckled shoes and go back to muskets if you're talking about the Second Amendment, or deprive women of the right to vote, deprive people of color of the right to vote. Originalist seems to be in the eye of the beholder, according to this court. So where do you see this court positioning itself as to how far back it would like to go?
Well, of course, I mean, I'll just say as an introduction to that subject, I mean, there's nothing original about originalism. As a method of constitutional interpretation, it was invented by right-wing tanks, the Heritage Foundation, Ed Meese, who was Reagan's Attorney General. They came up with this in the late 1970s and early 1980s as a way of undoing, modern constitutional law. So how far would this court go? Well, it's very interesting. So people may have heard of the Bruin decision, the Second Amendment decision that written by Clarence Thomas, that held that the only restriction on the ownership of firearms that is constitutionally valid under the Second Amendment is something that reflects either precisely or by a very close analogy to a restriction that was at issue back in the 18th century or back at the time that the Second Amendment was enacted. So, how can that be actually? Because, of course, in those days, they didn't have the kind of, super armaments that people walk around with today. So it's a theory, it's a method of interpretation that simply defies logic, but it got a majority vote. Then fast forward from Bruin, which was 2 years ago, to the case that came down this past June, the Rahimi case. So the Rahimi case posited under the Second Amendment that it was unconstitutional for the federal government to deprive of the right to own a gun somebody who was under a court order for domestic violence. That was a law that was about 40 years old, federal law, and the Fifth Circuit, the appeals court that's the most Trumpified, the most conservative in the country, had held that that law violates the Second Amendment. So this put the court to quite a test because, of course, in the early years of the country, and until very recently, in fact, there was no concept of domestic violence. Wives were the property of their husband. And so the notion that there would have been a restriction on gun ownership for domestic violence, you're not going to find it back in the 18th century. But yet the court found a way. It was a very disunified majority, but it was a majority to uphold the law and overturn the Fifth Amendment. So So what the Second Amendment means right now is very much up for grabs. And there's a whole lot of litigation in the lower courts on, for instance, uh, uh, what about machine guns? What about age limits on gun ownership? What about um, depriving people convicted of felonies of the right forever after to own a gun? This is all being litigated, and and Trump judges are going one way, pro Second Amendment, pro gun, and non-Trump judges are saying, we read Rahimi that really the court sees some daylight here, and we're going to uphold these laws, and we're going to see that's going to be back in the court within a matter of months.
Um, I have read that because several of the more recently appointed justices came out of the Justice Department, out of the executive branch, that they have this sense of impatience with Congress, that Congress is slow and messy, and we like the executive branch because you can just get things done quickly. And that sense may be governing some of the, or at least coloring some of the decisions that we're seeing now out of the court, like the Chevron doctrine, which we'll get into in some detail, but that it is all that is the court is cohering more and more around that idea of the unitary executive, where of the three branches of government, the executive is the more powerful, in spite of the fact that they're now in the judiciary.
Well, yeah, I mean, there's many layers to what you just said. I think they do believe in the unitary executive, but on the other hand, they seem to have a very low regard for the executive branch and for the agencies that make up the executive branch. So, what the Chevron doctrine case was about, the court said, we said in the Chevron case back in the 1980s that uh, if there's an ambiguous statute, but the federal agency who's governed by that statute has come up with some plausible interpretation of the statute in the regulation that they've issued, we judges have to defer. What the Loper-Bright case, the case this term that overturned Chevron, what Chief Justice Roberts said is, actually, we're the ones who say what the law is. And this notion of deferring to a federal agency uh, is just flat out wrong. And we do not defer, and we decide. So it's an arrogation of power away from the executive branch and right into the laps of the justices.
So what I heard about the Chevron doctrine is that essentially the idea when Congress would say, we want clean water, here's our clean water bill, and we're going to leave it to the educated water experts in the executive to determine what it takes to do that. The way you might hire someone to put a roof on your house, you tell them we want a roof, and they're the ones who know how to go about doing it. But that the Supreme Court has now said, well, because Congress wasn't specific in every particular about how to bring about, say, clean water, that's all up to judges who, of course, have no expertise in how to bring about clean water. How does that ultimately play out, do you think?
Well, we're going to see. You know, even before they overturned Chevron, they were, I mean, for instance, in the Clean Water Act example, it was 2 terms ago, it was an Alito decision that told I guess it was the Environmental Protection Agency, uh, told the EPA what a wetland is and the extent to which the government could regulate the use of wetlands. And it gave a very narrow definition of you had to have, visible water. It had to be very close to visible water and so on. The notion of, the underground channels and water supply just seemed to elude the majority in that case. And that was, exactly what you're saying. I mean, there was a whole lot of expertise on the necessity of protecting wetlands and the environment that the court just kind of threw into a cocked hat. It was a very important decision called Sackett, Sackett, that didn't get much attention because, of course, it came down around the same week as Dobbs, the abortion case, and so people didn't really pay attention to it. But it was a window into how the court is not deferring to the expertise that resides in what we like to think of as the expert agencies of the executive branch.
Linda Greenhouse is my guest. Since the late 1970s, she covered the Supreme Court for the New York Times and for 14 years taught at Yale Law School. If you have questions for her, we'll get to them a little later in the hour. You can put them in the Q&A box and I'll get around to as many as I can. The Dobbs decision 2 years ago, ending almost 50 years of Roe versus Wade, was, to some people, obviously galvanized Americans politically, particularly American women, but it may also have been a case of, I think you may have used the phrase, the dog catching the car. Be careful what you wish for, it might come true, because not only did this put conservatives politically at risk, as we saw in the midterm elections, but it really undermined, to a lot of people, the credibility of the court. You know, the last 3 justices who were asked about this during their confirmation, yes, Roe is settled law at the first opportunity they get, and welcome the opportunity, to some people's minds, of overturning Roe. What kind of court is it that has any stability or regard, which is a fundamental in American jurisprudence, if it can't stick to its own decisions?
Well, yeah, I mean, there's so much to say about Dobbs, but the thing that most people don't say, but I will say here, it was a case about religion. It was a case about preferring the fetus to the born woman living her life. And, you know, that's kind of buried, running throughout the Alito majority opinion in Dobbs. You know, it's no accident that every member of the Dobbs majority was raised in the Catholic Church. Maybe that's not politically correct to point that out, but it's got to be the truth. And you read Dobbs, and most people don't actually sit down and read it. It's more than 70 pages in the Alito opinion. There's no law. There's no law in Dobbs. It's a bunch of right to life talking points, you know, about the fetus and about why Roe is egregiously wrong from the very beginning. Well, you know, it's what people need to realize is that the Roe decision in 1973 was 7-2, and 3 of Richard Nixon's appointees were in the majority, including the quite conservative Chief Justice Burger. And the Casey decision in 1992, which Dobbs also overturned, was a 5-4 decision, and all 5 were appointed by Republican presidents. All 5 in the majority that reaffirmed the right to abortion were Republican appointed justices. So for Justice Alito to sit there and say, these were egregiously wrong and we need to overturn them, is the arrogance of it. And you know, that requires some kind of law-based explanation, but you can read Dobbs, you can stand on your head and read it 10 times, and you will not see any law in that opinion.
And yet the objection to Roe, the fundamental argument of Roe, is that it invoked a right to privacy that didn't exist.
Well, you know, Roe was based on a set of precedents that actually had recognized the right to privacy in the birth control context, that Clarence Thomas says, oh, maybe we should take a look at that too. You know, I mean, the notion that Roe, you know, drop from the sky, a bolt from the blue is actually, you know, not accurate. It's part of the mythology, it's part of the narrative. But it was grounded in privacy, yes, but more fundamentally, the notion of constitutional due process and what that means. And the you know, jargon is substantive due process, which conservatives hate because it implies that there's some substance to the 14th Amendment and not just procedure. And that's where Roe came from. And you know, you can, as I say, read Dobbs and not understand at all what the court thought it was doing in Roe.
You also begin to wonder about what's going on with confirmation hearings when you do hear nominees say, no, Roe is settled law. You know, Roe is over and done with, the colors are nailed to that mast, and yet voted to end it on, as you pointed out, a very thin argument that was not perhaps constitutional at all. What is the larger implication for the court if this kind of thing is going on?
Yeah, I mean, what to say about the confirmation hearings? I mean, it's become very formulaic, and what these nominees say is, I recognize that there is a precedent on the books called Roe against Wade. I recognize that, but they won't go further to say, and therefore, uh, but I can't say what I would do about it because, I can't bind myself. That would be unethical, that kind of thing. The saddest thing I think was Senator Susan Collins, Republican of Maine. She was really a key vote in the Kavanaugh confirmation, and she came out of her uh, private meeting with Judge Brett Kavanaugh, saying, "I'm persuaded he's going to uphold Roe against Wade." I rather doubt that he said any such thing. I don't think he flat out lied to her. I think she heard him say what she, as a loyal Republican, needed to hear him say, because she wasn't going to go against, the party. And, there we had it. So I think the writing was on the wall. People just didn't want to, I should say, the progressive side of the street, people knew it, and yet there was a kind of a cognitive dissonance. There was shock when Dobbs came down, when remember the leak was a month before the actual opinion, or like 6 weeks before the actual opinion came down. People were shocked. Well, they should have been paying more attention.
If there were a Democratic president, a Congress that passed a national law legalizing abortion, would the court throw it out?
Well, of course, what would the court be at that time? I don't think so. Well, okay. So one question a conservative justice would ask is, what power is Congress invoking as the basis for this action, right? So if you remember Obamacare and the individual mandate to buy insurance, right? Uh, that was questioned very intensely under the Commerce Clause. Congress needs some kind of constitutional hook to do its job. And commerce used to be a very expansive concept that gave Congress the right to pass the civil rights laws, because commerce is involved when people travel across state lines to check into a hotel without discrimination and so on. So you could see the right wing coming up with an argument that under the Commerce Clause, Congress doesn't have the right to pass a national right to abortion law. Now, what's wrong with that argument? We see what's going on today, where we have a nation of abortion refugees, of women by the tens of thousands traveling across state lines, leaving their home states to get reproductive health care. So it's obvious that there's commerce in reproductive health care, interstate commerce, that is clearly within Congress's jurisdiction. It's just a matter of fact, not even a matter of argument. But, you could see the right wingers coming up with such an argument.
This has been called the Roberts Court, but as we have seen, the numbers of people for their regard and respect for the court has been diminishing considerably. Is this not a concern for Chief Justice Roberts? And it seems like he's the shepherd whose sheep have all escaped from the fold.
Yeah, I'm sure it's a concern. I mean, his name is on the door, as you say. It's the Roberts Court, and the court now, the public esteem for the court has fallen to record low levels. It had historically in recent history been running at about 60% public approval. And now it's down at about 41%, plunged after Dobbs, plunged before Dobbs, actually plunged after the court refused to issue an injunction against the Texas SB 8 law, the vigilante law. That was in the fall of 2021. So I think the chief has to be very concerned. You know, he tried to stop Dobbs. He's not on board with what the court did in Dobbs, but there were 5 justices to his right who just went ahead, even though his separate opinion says, you know, this is going to be, I forget exactly the words he used, but basically an earthquake in the legal system. What you're doing, we don't want to, we don't need to go this far. That's not the question in the case. The question in the case was, what about Mississippi's ban on abortion after 15 weeks of pregnancy? That would have been a cataclysm in itself had the court simply stopped there and upheld the 15 weeks, because that's way before viability. So it would have undermined the whole premise of Roe and Casey, but it would still have left abortion as a legal right for most pregnancy terminations. Roberts tried to stop it, but they outvoted him.
President Biden has proposed some changes for the court, including term limits, ethics rules. So what do you think? Obviously, those are not being well received by the court. I think we heard Justice Gorsuch dig his feet in about that. But and even the question of expanding the court to match the number of appeals court districts. But let's start with why the Supreme Court is not subject to the ethics rules that other courts are in the federal justice system.
Yeah, well, you know, there's been a fair amount of misunderstanding about this. Some of it, I think, propounded from the progressive side because, you know, it's politically advantageous to attack the court as being corrupt. I don't think, actually, personally, I don't think the court is corrupt. I think it has certainly a Clarence Thomas problem, but I don't think it's more general than that. But in any event, it's not the case that the court has no ethics rules. The court, there's a law called I think it's called the Ethics in Government Act, that requires the justices, along with all other federal judges, and I think some other federal employees, to disclose their outside sources of income, limits the ability to make outside income, puts other limitations, and the justices are bound by that. The problem with Clarence Thomas was he didn't follow it. He didn't report the hospitality that he was given, you know, by his billionaire friends. And so it's not that there's not a set of rules. They all, most of them follow it, you know, very carefully. So the question is, how do you enforce it? What's the enforcement mechanism? For the lower courts, there's a very specific enforcement mechanism of a complaint mechanism and so on. For the Supreme Court, who's above the Supreme Court to enforce it? So that's the issue, really. And, you know, there's various proposals and they make a certain amount of sense. But there's objection to them that it would interfere with the court's independence and so on. And, you know, I really think what it comes down to is back to what we were discussing earlier, the confirmation process. We the people, have to do what we can to make sure that people nominated to and confirmed to the Supreme Court are people of integrity, who will follow the rules and do the right thing. And beyond that, this may sound naive, but beyond that, I'm really not sure what could be done about it.
Is there, because Clarence Thomas and the great ProPublica reporting about these gifts that he was taking was almost like a game show as the stuff was coming in, you know, hundreds of thousands of dollars worth of stuff not reported and now being reported after the fact. Even had he reported them at the time, could anything have been done? Or was it just saying, hey, here it is. This is the stuff I'm getting. What are you going to do about it?
Well, I mean, that would have been a public disclosure. And I'll just say something else. I mean, um, there was some ambiguity at the time that he didn't report these gifts, um, to what was reportable and what counted as personal hospitality and what didn't. So the administrative office of the U.S. courts, which is the agency that kind of manages things and is basically run by the Chief Justice, back earlier this year, after all this stuff broke, put out new guidance on what the law means and what is private hospitality. And it made it quite clear that, to fly on somebody's personal plane or sail on their personal yacht or be taken to their private resort in the, Northwest or whatever, that's outside the category of personal hospitality. Personal hospitality is, if I invite you to dinner, you don't have to report that. But if I, put you up in my at Jackson Hole or something, that would be reportable. So going forward, that's clear. The reason they put out this guidance is obviously before that, it wasn't all that clear. There was kind of an escape hatch, and that's now closed. So going forward, I think maybe we'll have less to worry about.
And Clarence Thomas was on the record complaining that the justices didn't get paid enough. And obviously, if you're hanging out with billionaires, you figure yourself a pauper. But things like that really don't sit well with a public that they're earning six figures and people are making it on $50,000 a year. Does even that register, that kind of sense of
Yeah, well, yes. I mean, I have a certain sympathy for the justices in the sense that they have these law clerks and who are, like 25 years old. And the law clerks leave their employ after a year. Clerkship is 1 year. And they go out into the legal marketplace and they get bonuses for signing up with a law firm of, I think it's now $100,000. And within a couple of years, they're making more money than the justices. So if you're sitting there, at the top of the heap in the legal profession as a Supreme Court justice, and you see this, um, I'm sure it stings. And uh, it's not very politic to go around complaining about it, but I think that's a real issue. Uh, and certainly living in a place like Washington, they don't get a car, they don't get a house, they don't get any of the trappings of power that very powerful people get. And they're just living their lives. And we used to see Sandra O'Connor at the local hardware store, that kind of thing. And so I, I think, actually, I think all of our public servants should be paid a lot more. It would solve a lot of problems, but there we are.
Before we get to our audience questions, I want to ask you about some personalities on the court. I think the two newest members are also both women, Ketanji Brown Jackson and Amy Coney Barrett. And where do you see their voices and their influence in this court?
Well, they're both very interesting. Ketanji Jackson has used her voice very effectively, mostly in oral argument. She's not on the winning side of many cases, and so she hasn't had a chance to really, express herself in majority opinions. But she's asked, very penetrating questions on the bench in voting rights cases and so on that really, kind of call out what the real issues are. And I expect that she'll have a long and very, notable career on the court. Amy Barrett is pretty fascinating because, she's sitting in Ruth Ginsburg's seat. People remember that she was nominated by Trump before Ruth Ginsburg was even, in the ground, and confirmed at the end of October, in time for the election.
In violation of everything Mitch McConnell said should be done.
Totally, totally. And of course, she was one of the 5 votes in Dobbs. But having said that, she demonstrated this term a big chunk of independence, and it's clear that she's exerting some influence within the conservative majority. She's made it clear to Sam Alito, who I think may have taken her for granted when she came on the court, that she is thinking for herself. You know, she's the only one on the court who comes from real scholarship. She was a law professor of some distinction, you know, highly respected in her field. Um, I mean, Elena Kagan, of course, was dean of Harvard Law School, but she wasn't. She was a great legal academic administrator. She wasn't really a legal scholar. Amy Barrett was, and I think she brings to the cases that the court is deciding um, a really a different perspective on the evolution of law, and she's really very interesting. And you know, she's the youngest on the court, and she's going to be there for a long time, long after Sam Alito and Clarence Thomas are gone. And I'm intrigued by her, and I look forward to what she has to tell us going forward.
And it's worth noting that 3 of the members of the court are over 70, and whoever's elected president next may have an opportunity to fill at least one of those spots, and even 3, which would, of course, either cement or change substantially the direction of the court. Let's get to questions from our very smart viewers here. Here's a question from Jim. The most egregious decision by the Supreme Court was Citizens United. It led to an oligarchy of legal bribery by wealthy campaign donors. Is the only way to reverse it a constitutional amendment?
That's the question, is the only way to reverse it?
Yeah.
Yes, or by a change of personnel on the court that, as we've seen, is quite capable of, you know, overturning its own precedents. So, yeah, either the court changes its mind or we amend the Constitution.
A lot of people wonder whether you have any thoughts about who leaked the Dobbs opinion 6 weeks before it was actually issued.
Whether I know who leaked it, I, no, I don't know. My guess is it came from the right, uh, because, you know, the effort was, I think, uh, because the draft opinion that was issued had the 5 names of the people that eventually signed the real thing, and one of those names was Brett Kavanaugh. And we learned from reporting by my friend Joan Viskupik from CNN, very good Supreme Court reporter, that the Chief Justice was really working hard and lobbying Brett Kavanaugh to peel him off the Alito majority. Once the leak occurred and Kavanaugh's name was on the draft, that made it impossible for him to depart from that majority. And so I think that would be the motivation for the leak, but how it actually occurred and who did it, I have no idea.
They nailed his colors to the mast.
Sorry, say that again?
They nailed Kavanaugh's colors to the mast.
Yeah, right.
Eric wants to know, he said in the 1930s, FDR came close to expanding the court until the court started to change its decisions. Anything to learn from that and the prospect of expanding the court? 9 is not written in stone.
Yeah, I mean, Congress has the ability to set any number of justices. And, you know, of course, the FDR experience was one that kind of set that notion back for a couple of generations. You know, it's an interesting thought experiment. It cannot happen in our current political alignment because even though it's up to Congress, you know, we have a filibuster rule, and it would require a supermajority in the Senate to advance such a bill. You know, personally, I don't think I don't find it very appealing because, you know, whoever gets the majority ability to do that and adds a couple of justices, then when the pendulum swings again and the other side comes in and they add a couple, and then you come back and they add a couple, and you know, I'm not sure where that leads us, but it's, you know, it's in the realm of theoretical possibility.
Well, to paraphrase Jaws, we're going to need a bigger desk. if that happens.
Right.
Renata says, would you speak to the controversial involvement of the wives of Alito and Thomas in political extremist expression and the decisions the justices are involved in? Should the justices recuse themselves? Because we have seen Ginny Thomas very active in the January 6th effort to try to keep Trump in office. We had Martha Alito hang out a distress signal flag around the same time and take part in an argument with her neighbors over this, which seemed unseemly in the fact that it went on and on. So perhaps you can talk about this, because in the past, the spouses of the Supreme Court justices were not on any real public radar at all.
Yeah, I mean, it's both a tricky issue and a very clear issue. I mean, certainly Thomas should have recused from the Trump cases. I don't put Ginny Thomas and Mrs. Alito in the same box at all. Ginny Thomas was, part and parcel of January 6th and the run up to it, and was advising the Trump administration and so on. And so, did she have a right to do those things? I suppose she did. And do we want to make somebody who's the spouse of a Supreme Court justice, put them in a box and not let them live their life? No, of course not. But she really overstepped any kind of bounds, and certainly he should have recused. The Alito situation, I mean, uh, i- if I were Sam Alito, I'd be very embarrassed about it. But I wouldn't say that's recusal material. So, it's easy to conflate those two situations, but I think that's a mistake.
A couple of points. Let me ask both of them and then you can address them together. Carol wonders why it's impossible for the IRS to look into Clarence Thomas for not reporting these gifts. And Andrew points out that Abe Fortas on the court was asked by Chief Justice Warren to resign over a $20,000 gift, but nothing is happening over these multi-million-dollar Clarence Thomas gifts. What can be done about the lack of ethics? We've gone some way to addressing it, but are there not mechanisms like the IRS, as Carol suggested, that are outside of the actual nature of the court, but certainly a tax matter, which, that's how they got Al Capone.
That's an interesting question, but of course, IRS investigations are private, and maybe there is one. I just have no idea. I mean, in the Fortis situation, about which I am not an expert, but my understanding of it is that Fortis was essentially on the payroll of a guy named Lewis Wolfson, who had business before the court, but he and his friend Abe Fortas, the justices were very, very badly paid then, and Fortas had been a very high earning, major player in in the legal profession in Washington. And so Wolfson was kind of propping him up by giving him a stipend. So that became unsupportable when I guess it was Johnson nominated Fortas to be Chief Justice, because Earl Warren had indicated that he was going to retire. And it was at that point, and then the Nixon administration came in and the whole thing kind of unraveled. It was, highly political, but a somewhat different situation.
The name Leonard Leo has come up a lot recently in reporting about another one of these billionaires whose money is going into supporting judges and helping to campaign for judges to put them on the court, sometimes indirect support, sometimes more direct. What are your thoughts about this kind of money, which again goes back to Citizens United and the larger political field? But justices are not political candidates, but still there's so much money in the justice system, in the judiciary system. It's moving along and upward into the even into the Supreme Court.
Well, Leonard Leo's role is very large, and he and his sort of cadre have been the judge pickers, and the money that flows was in support of the confirmation of the Trump justices, and it's not going directly to the justices themselves. It's the political ecosystem that is funded by this flow of dark money with Leo at the helm of it. It's very interesting. I mean, if in fact the Dobbs opinion, which of course was enabled by the justices who Trump put on the court, who had been put forward by, with Leonard Leo's urging and stamp of approval, if the Dobbs opinion results in Democrats taking back the White House, um, there's a certain irony there, right? And that Leo could have been the field marshal of an effort that was a short-term victory and a long-term change of our whole political environment. So we'll see. But yeah, he's been a very, very important figure.
If there's no chance really of Congress expanding the courts, David and others want to know, what about the idea of term limits for Supreme Court justices? Would that be subject to filibuster level voting? Does that have any prospects?
Well, so the issue with term limits, which in the abstract is a perfectly sound idea. I mean, our Supreme Court is the only high court in the world that doesn't have either an age limit or a term of years limit. It's nobody else has chosen to copy us. The problem is Article 3 of the Constitution provides for life tenure of all federal judges. So you'd get a very strong argument going that to impose term limits would require a constitutional amendment. Now, on the other side of that argument, it really wouldn't. You would simply say that once a justice had reached 18 years is the usual limit that's put up in this conversation. That justice would stay on the bench, would still be a federal judge with full benefits and so on. It's just that they wouldn't sit to hear any Supreme Court cases. The new justices would kind of take their place. Well, it's a kind of an awkward workaround. So I don't know if that would fly, but even if it did fly, let's just assume term limits come in. They certainly can't apply to the incumbents. We know that. So it'll all be prospective for future nominees. And one set of figures that I saw said if that's the case, by the time all 9 sitting justices would be subject to term limits, would be in the year 2046 or something like that. So, it might make people feel better about the court, but I hope I'm alive in 2046. Well, of course, Janice's mother is alive at 100, but I'm not holding my breath to see the impact of term limits.
Well, you could always invoke the originalist argument and say in the 18th century, people only lived to age 66. So let's be originalist about it and keep people off the court after that age. The actuarial tables would dictate it.
Well, that's very interesting, Pat, because I once actually interviewed an actuary about this. And I said, what about the seeming longevity of the justices? They seem to live so much longer than the average person, starting from the very beginning. John Marshall, a lot of early justices lived a long time. So what this actuary said was the 2 longest lived job categories known to actuaries are federal judges and orchestra conductors. Why is that? Orchestra conductors is because they get a lot of cardiac exercise, right? Federal judges because of life tenure, they don't have the stresses that most working people do. Am I going to have a job tomorrow? And, am I getting my boss mad at me? The worst that can happen to a lower court judge is they have a decision that gets overturned, but they still have their life tenure. So, so actuarially, we can expect justices to be around for a very long time.
Linda wants to know whether Chief Justice Roberts had the authority to make Thomas recuse himself from the Trump cases that touched
He does
on
not.
the side.
He has no authority over anybody else.
What power does the Chief Justice have besides assigning cases?
Many fewer powers than people assume. I mean, he has a lot of power over the entire federal judiciary in terms of, managing various aspects of really judicial administration by, um, a lot of that is delegated authority, but he picks the people that he's delegating it to. But in terms of the decisional process and in terms of the independence of the other 8 justices, each one of whom has been independently confirmed to their life tenured position, he has no authority over them. It's only the authority of, moral persuasion. And, that comes from leadership skills and, you know, building a, a kind of atmosphere of mutual respect and so on. And maybe that does not obtain in the current court. I'm not an insider enough to know, but he doesn't have, on paper, he has no power over the others.
Mark wants to know what you think might happen if the election winds up before the court, given that election boards have so many Trump supporters on them, and that states have been moving, in some cases not legally, to refuse to certify legitimate election results.
The answer is I don't know. The court did something last week that I found very disturbing. It was really under the radar, and probably people haven't heard about it. But a case came up to the court on an emergency basis. The court's not in session, brought by the Arizona Republican Party, um, asking the court to put a stay on a lower court opinion. It's procedurally very complicated. I don't want to get lost in the weeds, but it had to do with Arizona's ability to require hard proof of citizenship before somebody can register, not just voter ID, like a driver's license or something, but proof, a birth certificate or a passport or something like that. And as I say, it's very complicated, but the court did something it should not have done, which is to let Arizona go ahead and put this requirement in place for a certain category of would-be voters. That was over the dissent of Elena Kagan, Sonia Sotomayor, Ketanji Brown Jackson, and very interestingly, Amy Coney Barrett. The 4 women on the court were the dissenters. And uh, that this obscure case went down that way, to me, sent a kind of scary signal. So it's a very good question, and I do not have a very good answer.
We have seen since the gutting of the Voting Rights Act that a lot of states have been moving aggressively forward to purge voter rolls, to impose regulations, as you say, like Arizona's. And of course, elections are conducted by state and local agencies, not by federal agencies. And yet it seems to be, to use Barry Goldwater's phrase, Katie bar the door for these states to start looking for how to disqualify and disenfranchise voters rather than winning elections, which is what the political aspects of the nature of running the country are about. The judiciary seems to be working in some cases hand in glove, allowing this to happen.
Yeah, absolutely. The gutting of the Voting Rights Act was a very bad thing, the Shelby County decision. That applied to a specific, category of states. That was basically the South, I think part of Arizona. Anyway, that was not a national law. So what's going on, as you say, it's state by state. And it seems that, the main strategy the Republicans have for winning elections is keeping people from voting who they think are going to vote for the other party. And um, it's very worrisome. And uh, the federal judiciary seems to be having a very hard time getting a handle on it.
I started this hour by asking you about the 1970s when the court limited presidential power when President Nixon came to the court to ask for immunity. And Bill now asks you to comment on the presidential immunity decision by the Supreme Court recently. Its presumptions that presidential actions are de facto legitimate.
Yeah, I mean, it's a very confusing opinion because it set up these three categories that anything that counts as official action in the core of a presidential authority is immune. Anything that is obviously not official action is not immune. But where the rubber meets the road is this category in the middle. And that's what Judge Chutkan has to figure out. She has to go through the indictment and categorize each of the special counsel's claims to see which category it fits in. And she's asked for more time to do that. It's just very unclear. So, how this is going to shake out. I mean, during the oral argument, Michael Dreeben, who was arguing for Jack Smith, the independent counsel, said, even with a broad understanding of immunity, which of course they were arguing against, but even if Trump wins like a lot, we still have a case because a lot of these January 6th actions, we can argue, were not within the core of his official duties. And that's pretty clear. How clear it is going to take a long time to shake out, depending on, ultimately depending again on the court. So it really leaves the whole thing in quite a mess.
Because very quickly, in the minute or so we have left, a lot of people think the court is simply in the bag for Donald Trump.
No, I don't think so, actually. That's too simplistic. I think the court felt rather that it was kind of speaking for the ages and not about Trump, but about, the presidents to come. So I reject the in the bag theory.
We try to end with a minute or two of something optimistic and hopeful. And with your deep knowledge and wide range of perspective, maybe you can give us some of that about the court and the federal courts generally.
Well, I mean, I guess my hope would be that people are finally paying attention to the court. Part from a progressive point of view, part of the way we got in the fix we're in is Democrats kind of took the court for granted and didn't pay attention. So in 2016, after McConnell blocked President Obama from filling the Scalia vacancy, wouldn't give Merrick Garland a hearing, that should have been an issue that Democrats voted on. Instead, it was an issue that Republicans voted on to make sure that the president who was going to fill that seat was going to be one of theirs. So the good thing is now, now we know it's a little late in many cases, but the future lies ahead. And I think the health of the judiciary depends on an informed citizenry that really cares and holds the elected officials to account when they do something that is inconsistent with good practices, as happened in 2016.
Linda Greenhouse, the longtime New York Times Supreme Court reporter, longtime professor at Yale Law School, and author of many books that you can find online, with a new court session coming up. Linda, I hope you'll come back and talk to us.
I'd be happy to.
Linda Greenhouse, thank you so very much.
Thanks for having me.
On Wednesday, I'll be talking to Leon Panetta about an expert's view of our world in chaos. And I do want to thank everyone who watches and supports this program at a time in our nation's history when it's so vital to have voices like Linda's and Leon Panetta's coming to you and you being able to put questions to them. So thank you to our organizers, and thank you to all of you who watch and support these programs. I'm Pat Morrison.